AL and Secretary of State for the Home Department.
Yes, Mr. Jones.
Your Ladyship, I obviously appear for the appellant in this matter, and my learned friend, Mr. Uddenast, appears for the Secretary of State. Your Ladyship, there is I had the opportunity to discuss the case briefly with my own friend, and there was one matter he wanted to raise with regard to an aspect of his skeleton argument, but I wonder whether it's probably more convenient to deal with that when he begins his submissions, given that I wasn't actually going to address any submissions to.
Right, well, we don't know what it is you're talking about, so we'll trust your judgment.
I'm grateful for that indication.
You think is most convenient. The case is being live streamed, and I think there's an order retaining the confidentiality as to the identity of the family members. So I'm sure we'll all conduct ourselves on the basis of, without mentioning any names. If any are mentioned, I think there's a button I can press, which is here. It's not very convenient, but we should be all right on that basis. We've read, certainly read your skeletons, for which we're very grateful, the judgments, and we've delved into the bundle variously to different levels. So we've got quite a good understanding of the issues in the case. Have you discussed with each other how long each of you might think you might take?
We haven't had that conversation, Lord.
Yes. Well, what's your position, Mr. Jones?
I would hope, Your Lordship, that I'll be able to finish within a couple of hours.
Yes.
Maybe a little quicker. It very much depends on
how
how
much
I
we
fare.
interrupt. Yes.
But I think before lunch for certain, and
Yes.
I would hope. I imagine my own friend would have a similar amount of time, but I'm not sure.
Yes. Certainly, for my part, I'm particularly struck by the respondent's approach to the case of Latter and the question of whether the case as is now being run before us was actually in issue before the first year tribunal. But I'm sure you'll cover all the ground, but that perhaps is particularly an area that you need to be.
Well, given that was the
persuading us.
yes, I mean that Your Lordship, that was obviously the focus of the Upper Tribunal's disposal
Yes.
with regard to Article 3. So we will spend some time on that. Hopefully, I'll be able to reassure you that it's not the knockout point that it might initially look like.
Yeah, well, that's plainly your goal. Yes. Good. Thank you.
So I'm grateful for the indication that Your Ladyship had a chance to read into the papers to some extent. I will just very briefly sort of encapsulate what this case is about. We are before the court today pursuing an appeal against a disposal by the Upper Tribunal, which Your Lordship is obviously familiar. That appears in the core bundle at page 58 and dates from April of 2024. And in that determination, the Upper Tribunal recorded two findings in respect of the two grounds of appeal which are admitted to it, to the effect that, as Your Lordship has already indicated, the Article 3 claim that was being advanced was regarded as not having been advanced in the tribunal below, and consequently was not a matter upon which an error of law could be fixed by reference to the previous first-tier tribunal's disposal. And then with regard to Article 8, that the disposal of that issue by the first tier was not irrational or flawed in law. Both those matters were taken forward to this court, and the two grounds of appeal that are before Your Ladyship. Ground 1, the assertion that the Upper Tribunal erred in concluding that the health impacts on the appellant of being separated from Hugo's family were not raised before the tribunal, or in the alternative were not in evidence. And then ground 2, the position advanced that the Upper Tribunal erred in upholding both the very significant obstacles and the Article 8 proportionality disposal of the first tier tribunal. Now, predictably, going to address each of those grounds in turn and focus on the first ground, because in our submission, the approach to that disposal by the Upper Tribunal, and then to a lesser extent the first tier tribunal, is determinative of the case generally. With regard to ground 1, I'm going to be making submissions to the effect that it is a vital aspect of the evaluation that failed to be performed by the tribunal when determining whether there was an Article 3 interference on health grounds, to actually know and understand the nature of the condition with which the appellant presented, and also to know and understand the significance of the care relationships that the appellant had fixed in the United Kingdom. And to assist the court, and I hope it does assist, and I provided this to my own friend, we prepared a schedule of the critical aspects of the expert evidence with regard to the appellant's medical condition, and also, where appropriate, referencing the evidence of the witnesses, which I hope may enable us to sort of move through those materials a little bit more expeditiously in the course of submissions.
Thank you. Thank you.
Now, the court would appreciate that with regard to the Article 3 claim, there was no issue between the parties. It was accepted by the respondent, and it was found and endorsed by the first tier tribunal that the appellant presents as a seriously ill person.
Yes.
And if it assists the court, I'll very briefly give you the references within the first tier tribunal determination which make that position out. I needn't take you to them, but your lordship will be assisted by a reference at page 116 of the core bundle, paragraph 114. Then again, at page 128, paragraph 178. Page 130, paragraph 194. This is all first tier tribunal disposal. And then finally, page 134, paragraph 219.
Yes.
And the significance of those findings is essentially that the position was accepted before and remains the position before this court. The appellant presents as not only a very seriously ill woman, but also a woman presenting with very serious medical conditions, in particular major neurocognitive disorder, which has been described as significant or serious in the latest consultant psychologist report. She also presented before the first tier, and for the purpose of this disposal, presents as a person with major depression and anxiety symptoms. Also, and your lordship will find the diagnosis on the first page of the schedule I handed up to you,
Yes.
just to assist. She also found, and this is significant on the submission of the appellant, presented at the time of the hearing as a person lacking capacity,
Yes.
and as being defined as a vulnerable person within the definition of the legislation relating to capacity.
That's paragraph 122. I accept the appellant as she appears before me as a vulnerable adult who lacks capacity.
Indeed.
Not disputed by the respondent.
I'm so sorry, Mr. Jones. I'm not sure I got all your references to the paragraphs in the FTT's determination,
Of course.
which you rely on in support of the proposition that the appellant's seriously ill. I got 114, 178 and 219. Were there any more?
So, yes, 114. I'll just check
I'm
again.
so sorry. It's my
Not
fault.
at all. Not at all. 178,
Yeah,
178.
194,
194.
and
219?
219. Yes.
Right, lovely. Thank you so much. Sorry to
Not
interrupt.
at all. Factored within the medical background to the appellant as well was relevant findings that she was a person who presented with a history of hypertension, and also had, although the causation is not certain, had a number of mini strokes which are likely attributable in part to that hypertension or related symptoms. Although I think Dr. Hecke indeed alludes to the impact of stress on the presentation with stroke, previous mini strokes. And the number of mini strokes is, I think, described in the medical records. The GP record described 2 mini strokes having occurred in 2016 and 2019. Those GP records appear in the supplementary bundle at page 67, and the reference to those mini strokes is in the left-hand column dating October 2019 and 2016, the 5th entry down. Cerebrovascular accident 2019-2016. And you also then have a GP's letter, as well as the appellant's own evidence, to the effect that she suffered further strokes following her admission to the UK, the latest of which, on her evidence to the Secretary of State in the course of her interview, was that she'd had a stroke, I think, on the 29th of July 2020. So, perhaps unsurprising that the appellant was accepted to be a person who was seriously ill.
Yeah.
And the sequence of that is multiple. Its particular significance for the purpose of the Article 3 assessment was that it resolved the first of the two questions that the tribunal had to ask with regard to whether or not an Article 3 case could be said to be made out. Judges, you will be aware that the complaint that went before the Upper Tribunal, which was rejected, which now comes before the court with regard essentially to the application of the latter principle, was fixed originally on a contention that there had been a failure by the first-tier tribunal when assessing the second aspect of the medical case under Article 3 to evaluate the implications for the appellant of separation from her established care network in the United Kingdom. And that was a critical complaint which was articulated with clarity to the Upper Tribunal, to which the Upper Tribunal responded in its grant of leave in a significant way, making the observation, and you'll find the grant of leave in this case at page 65, decision by Upper Tribunal Judge Landers, who at paragraph 2 said this: while there would be another female, her sister, in the second sentence, who could provide the appellant with intimate care in the DRC, Dr. Hecke's evidence was that the appellant required regularised and consistent support, not just on practical but on an emotional basis. The judge, in her very clear and detailed and careful decision, to give cogent reasons why she did not accept the picture that only PE, that's the eldest daughter, could care for the appellant, or alternatively that the appellant would only allow PE to care for her. But it is arguable the judge did not consider the lack of consistency of support which removal to the DRC would bring, coupled with the distress of separation, which the judge acknowledged in considering whether the Article 3 case threshold was met. So that was essentially the platform on which the case advanced to the Upper Tribunal. Now, before the Upper Tribunal...
Would it be helpful to see what the ground of appeal was?
I can take your lordship to that.
There seem to be renewed grounds of appeal starting at page 79.
That's right, your lordship. The pattern is that there is initially an application to the first-tier tribunal, and then if that's declined, a renewal is possible to the Upper Tribunal, and you can revise one's grounds.
The ground of appeal sets out a good deal of factual background, but it seems to be paragraph 12. Described as the key submission under this ground.
Yeah.
Separation from the primary carer, the subjection to an enforced removal process per se.
Yeah.
Reached. So that was what was before the Upper Tribunal. Is that correct?
I think that's certainly the way Judge Landers appears to have formulated her grant of leave.
Yeah, that seems to be the way the appellant was formulating it.
Well, it was informed obviously by everything that preceded it, but that's a kind of summation of that preceding analysis.
But that's the ground for which the Upper Tribunal gave permission.
Yes, your ladyship.
And it's analysed in the Upper Tribunal's judgment at paragraph 6 on page 59. They set out the two headline grounds of appeal. Ground 1, in error in assessing intense suffering, separation from her primary carer, subject to forced removal, and then they tease that out at paragraph 8. Both grounds are based on the purported failure to take proper account of 3 discrete factors, which we read them all, and it's little 1, which is the separation from P. So the Upper Tribunal had it, didn't they? They had the ground as you're describing it,
yes.
particularly paragraph 12.
Firmly
in focus.
Sorry. And paragraph 10 fixes on that same paragraph as the key submission.
Yeah, paragraph 12.
Yes, your lordship. And I think there's nothing controversial about that. That has been the focus of the appellant's case, and indeed on the appellant's submission, that was the focus of her case before the first-tier tribunal also.
But it certainly was under Article 8.
It was certainly assessed by the first-tier tribunal judge under Article 8. But that we respectfully say that doesn't mean that it wasn't a submission that was advanced in respect of Article 3 as well. What it means is that it wasn't. All it means is the judge didn't engage with it at that point.
Well, one question will be, where was it raised under Article 3 in that form?
Yes, Lord. Well, the appellant's core submission is yes, it was. And what I'm going to do is take you to aspects of the pleadings, aspects of the record of proceedings, and the statement evidence of the advocate who appeared before the first tier tribunal
Yes.
to make good that contention.
Yes.
But our alternative position is that even were it not to have been articulated as it was before the upper tribunal, it was a point of sufficient obviousness to be one which the judge should have directed herself to in any event.
Robinson
obvious submission.
Your fallback.
That is indeed, Your Lordship.
But how can it be a Robinson obvious point if your primary case before the FTT was that there'd be no care available for the appellant from anybody in the DRC?
Well, Judge, again, that is how the first tier tribunal has interpreted the case that's been put, but that is not, respectfully, how we say the case was in fact put. It wasn't a question of no care, it was a question of, there were questions as to the adequacy of care and the availability of care. That did not exclude the evaluation simultaneously of the implications of the loss of existing care. Because there's an assumption made by the judge essentially that the care arrangements were interchangeable. And we say that that's not a position that one could to fix on based on the appellant's presentation. And it's to that which I want to direct your lordship's attention. But before I do that, I think it would be helpful not only to respond to some of the aspects of my own friend's skeleton argument on the way that the law force be interpreted, but also to frame those arguments about the matter being live and being Robinson obvious, to actually understand the context to evaluations performed by reference to Article 3 and medical cases. And so if you'll indulge me, I propose to take you to the key authorities and just to describe how, in our submission, the evaluative exercise that we say should have been formed by the first tier tribunal was one which was apparent from the way that the case law describes the process of evaluation in these kinds of cases.
Yes, no, I think
So-
it's important that we do indulge it, because this, in fact, is the focus of your appeal.
Thank you, Lord. So I think it'd be helpful then to just, first of all, understand what the protection that Article 3 is, what it affords individuals. And I think it's important to set that out at the outset, because a critical part of this case and the complaint that's raised is that the loss of support and care which the applicant has in this country will impact upon her moral integrity, her dignity. It will have consequences which will cause significant anxiety and trauma, potentially. And so understanding what Article 3 protection is about in these contexts is important. And I could ask your lordships and ladyship to turn up the decision of AM Zimbabwe in the Supreme Court, first of all. And that appears in the authorities bundle at tab 13. The first aspect, we will return to this decision. The first aspect of the decision that I want to take to you very briefly appears at page 229. The numbering is at the top right-hand side of the authorities bundle. And it's a reference, it's in the course of the court's evaluation of preceding decisions with regard to Article 3 health cases. And it's evaluated by the point it gets to paragraph 19 that we're going to look at, the preceding case of N, for example, which was the leading case until the decision in Paposhvili came out, and then was that decision was in turn revisited by the Supreme Court in this case, AM. The first significant aspect of the AM judgment that I draw your attention to is its reference to the case of Mwanje, and what is said there about the parameters of Article 3 protection in health cases. And if you'll forgive me, I'm going to skip over the comment to the extract which appears at the bottom of paragraph 19. And so this is an observation from the case of Mwanje, where 6 out of 7 judges giving a concurring opinion, having expressed reservations about the test which was prevailing at that time, which was the N test, which essentially was a test where it was necessary to demonstrate that return in the health case would expose you to an imminent risk of death. they said this: "We believe, however, that such an extreme threshold of seriousness to be nearing death is hardly consistent with the letter and spirit of Article 3, an absolute right which is among the most fundamental rights of the Convention, which concerns an individual's integrity and dignity." And so that point of emphasis is, we say, one of importance.
Yes, but it doesn't float free of the actual test which was adopted in Papashvili and then adopted by the Supreme Court in AM Zimbabwe. So it isn't enough to say that somebody's integrity and dignity are affected.
Absolutely not, Your Ladyship.
You've got to meet the stringent test that's set out in the authorities.
And I propose to describe that test to you as well, Your Ladyship. I mean, but I just wanted to.
How this helps.
Well, only to just set the context, because it's important to understand the quality of interference with Article 3 rights, which can inform a breach. And Your Ladyship makes the important point that it has to be a significant interference. But understanding the nature of the interference is also important, that the quality of interference. Because in a case of this sort, where you're dealing with an individual who's particularly vulnerable, the implications are not necessarily going to be immediate and physical. They will manifest by way of a reduction in capacity, a retardation of cognition and lucidity, and an increase in anxiety and stress. And it may not assist. I will do it very briefly just to give the context. But the other case I was going to take you to was the case of Ante, which appears at tab 14, the next tab on.
You're eventually going to take us to the actual test, are you?
I am, Your Ladyship. I will just direct you to this now, and you can consider it in the course of your deliberations. But I'd invite you to. I'm submitting you'll be assisted by the position described in by the Upper Tribunal in Ante. The relevant part of it at page 258, paragraph 53, all the way through to paragraph 55. And it's not necessary perhaps for you to read that now, but if I can just tell you what I say, the bearing of those paragraphs is, it's an acknowledgement that Article 3 is a living instrument. It's an acknowledgement, this is in paragraph 54, that the relative significance of an interference or an act against potentially impacting on Article 3 is one which is case sensitive, and it is an assessment which is performed by reference to the impact of conduct or treatment or circumstance on an individual's dignity. And then a repetition of that proposition in the extract from the case of Boyard on page 259, in paragraph 87 to 90, I'd submit will assist you. And they speak in particular at paragraph 87 about actions, treatment which humiliate or debase an individual, showing a lack of respect or diminishing him or her, their dignity, arousing feelings of fear and anguish or inferiority. So that's the context to Article 3, which I'm sure this panel obviously knows is an absolute and unqualified right. And I just flagged that up because one point that my own friend does take in his skeleton argument is a floodgates argument. We respectfully say that there is no basis upon which one can advance that argument in respect of Article 3, and we will go to we'll go to Papashvili, if I may, because that is the...
But if the case that, just catching up, the case that's quoted, paragraphs 87, 89 and 90, is the case of Boyard against Belgium,
That's correct.
which was a single slap by a police officer,
Correct.
which the Grand Chamber held could be sufficient to engage Article 3.
Indeed, George. And I flagged that because it's absolutely right that, as your ladyship said, that...
But you're running together two things, it seems to me, with respect, Mr. Jones. There are Article 3 cases about inhuman and degrading treatment, which Boyd is an example. But we're not dealing with that kind of case here. What we're dealing with here specifically is an Article 3 medical case, and the test is different.
The approach to the assessment of a breach is different and distinct and well defined, but the quality of that breach, the treatment,
the quality of the breach and the treatment don't matter if the threshold isn't met. So that's why I keep asking you, can you please focus on the threshold and why you say it's met in this case?
Indeed, Your Ladyship. Indeed, I'm going to do that now. If I could ask your lordship to turn up the case of Papafilo, in which AM Zimbabwe is based, and that appears in the authorities bundle at tab 24. And the relevant part of the court's assessment commences at paragraph 174, which is in the authorities bundle, begins at page 532.
Thank you.
And just really to look at paragraph 174 and to respond to your ladyship's observation about the threshold and the significance and substance of that threshold, the court makes this observation. The prohibition under Article 3 of the Convention does not relate to all instances of ill treatment. Such treatment has to attain a minimum level of severity if it is to fall within the scope of the article. The assessment of the minimum level is relative. It depends on all the circumstances of the case, such as the duration of treatment, its physical and mental effects, and in some cases the sex, age, and state of health of the victim. And so, absolutely acknowledging what your ladyship says, but it is a number of different factors specific to the individual which can convert what might otherwise not be an act offending Article 3 into one that does. And
when you come to apply the test.
yes,
But no one would say you apply the test in the abstract. You obviously apply it to the circumstances.
absolutely.
My lady's asking about the test.
Yes, and I'll take you on to that. But I was just responding to that point. If you could turn then to page 535. And this is where the test is set down. Before we look at the test, though, it's important just to flag what is said in paragraphs 81, 81, 182, because we say respectfully this is an answer to the Millay and Friends attempt to invoke floodgates arguments into this process. Before you do that, just over the page on page 534 at the top of that page, the Grand Chamber was describing the findings of the court in N, and it noted, for example...
I'm so sorry.
Did
you say page 534?
Yes, Your Lordship. Top of the page. This is...
in the court's view.
That's correct. You'll find there that in the case of N and the UK, which was the preceding case which dictated the treatment of these Article 3 health cases...
So that was a Ugandan national suffering from AIDS.
Indeed, Your Lordship. In that case, the Grand Chamber had made observations which could be interpreted as capable of bearing on a broader public interest position, albeit that it did subsequently go on to say that the focus should be on the evaluation of an individual's condition as opposed to public policy considerations. So there was under N an allusion to those sorts of factors. Importantly, however, the starting point of the Papos-Villa decision is a repudiation of that approach. Ladyship, Your Lordships, you'll see at page 181, the first observation of the court. The court concludes that from this recapitulation of case law, so everything that's preceded, that the application of Article 3 of the Convention only in cases where persons face expulsion is close to death, which have been the practice since the judgment in N, has deprived aliens who are seriously ill but whose condition is less critical of the benefit of that provision. So it is an overly stringent provision. It goes on at 182 to say, in light of the foregoing, and reiterating that it is essential that the Convention is interpreted and applied in a manner which renders its rights practical and effective, not theoretical and illusory, the court is of the view that the approach adopted hitherto should be clarified.
That's a euphemism for abandon, isn't it?
I think that's exactly what the Supreme Court said as well, that it wasn't mere clarification, it was essentially
Ditched.
a complete transformation. And that transformation is described then at page 183. Your Ladyship will be relieved I finally got there.
Paragraph 183.
Yes, I beg your pardon. And there is the test. It states, the court considers that the other very exceptional circumstances within which the meaning of the judgment in N and the UK may be raised as an issue under Article 3 should be understood to refer to situations involving the removal of a seriously ill person in which substantial grounds have been shown for believing that he or she, although not an imminent risk of dying, would face a real risk on account of the absence of appropriate treatment in the receiving country or the lack of access to such treatment, of being exposed to a serious, rapid and irreversible decline in his or her state of health, resulting in intense suffering to a significant reduction in life expectancy. So that's the test, and it's been broken down. It's broken down
by the word treatment.
Well, we'll come on to that. But I think what we say about the word treatment is it doesn't describe, or it isn't intended to describe, a particular form of medical treatment. It is a broad term, which then
Well, it's essential to your argument to say it isn't confined to medical treatment. So it's critical to know how wide it could be.
It's wide enough to embrace the situation of the appellant for certain.
Well, to express this in legal terms, you seem to be saying it covers personal care.
Yes, Your Lordship, that's precisely what we're saying. And it's important to note, and just to assist Your Lordship on that point, my own friend predictably and understandably relies, when seeking to uphold the Upper Tribunal and the First Tribunal's determinations, on the specialist nature of those tribunals. And indeed, doubtless will tell you, and correctly so, that Judge Bagra, in her determination, laboured extensively over the issues and facts in this case and the evidence. And indeed it is, as the Upper Tribunal described when granting leave, a detailed and comprehensive evaluation. But there is a converse of that, and that is this, that when the Upper Tribunal granted leave, as we've seen, and when the Upper Tribunal evaluated the error of law, neither tribunal expressed any reservation as to the capacity of the primary submission being advanced by the appellant to the effect that the deprivation of care was capable of impacting.
Well, let's look at it this way. Is there an authority which has extended Article 3 to a personal care case as opposed to medical treatment?
There is an authority which says that the assessment is not encumbered by the character of the condition. And by implication then, the character of the condition...
But the facts of that case, facts which raise the personal care issue.
There are facts which, well, Your Lordship, with respect, in respect of any person presenting with serious illness, there are going to be personal care dimensions.
They will be.
And
but the ground of appeal before the Upper Tribunal was the loss of personal care per se.
well, the first submission I was making, Your Lordship, was simply that, and correctly, the Upper Tribunal, in neither of its disposals in this case, expressed any reservation as to the capacity of the Paposh Villi.
Got that point.
I'm grateful for that.
I wonder what the answer to my question is.
The answer, well, let me take you then to a couple of authorities which I hope will assist you in meeting that concern. So, but perhaps before I do that, if I could just take you through the test, because I think that the Paposh Villi decision itself will assist you in understanding what treatment means and what evaluative exercise is required. So, having set out the test at 183, what the Grand Chamber then did was embark on a detailed explanation of the process which a member state has to go through in order to evaluate whether or not there will be a breach. And if you turn over the page to page 536, I'll take you through this in a little detail. It begins at paragraph 185, where the court says this: accordingly, in cases of this kind, and this is a case again which is concerned with perhaps a more typical Article 3 medical situation, which is concerned with, again, HIV. It says the authority's obligation under Article 3 to protect the integrity of the person concerned is fulfilled primarily through the appropriate procedures allowing such examination to be carried out. And then at 186, the first step. In the context of these procedures, it's for the applicants to adduce evidence capable of demonstrating that there are substantial grounds for believing that if the measure complained of were to be implemented, they would be exposed to a real risk of being subjected to treatment contrary to Article 3. And it goes on. In this connection, it should be observed that a certain degree of speculation is inherent in the preventative purpose of Article 3, and that is not a matter of requiring persons concerned to provide clear proof of their claim that they would be exposed to prescribed treatment. So that's the first step. A case has to be put forward which is capable of bringing an applicant under the umbrella of the protection of Article 3.
Well, it's substantial grounds for believing that, so I'd interpret that as a strong prima facie case.
Indeed, Your Lordship, and we have that, because we have we certainly have the respondent's acceptance that such a case exists. We have the tribunal's engagement with this protection case.
Where did the respondent accept that there was a strong prima facie case that the appellant would be exposed to a real risk of being subjected to treatment contrary to Article 3.
I suppose only I'm articulating that in reliance upon their decision letter, which, although it repudiates the existence of risk, it does not conclude that the case put by the appellant is so insubstantial that it is.
Sorry, were you talking about the original decision letter?
Yes, Your Ladyship.
The original decision letter was dealing with an asylum claim. The Article 3 medical issue wasn't introduced until later on, after there'd been an appeal to the FTT, and there was a whole lengthy process by which the Secretary of State was asked whether or not she consented to the raising of a new matter. So the original decision letter doesn't deal with this at all.
In fact, she hadn't become that ill at the time of the original decision letter.
She certainly wasn't as ill as she was when she appeared before the First Tier Tribunal, but it is the case, in fact, that the issue was put at the time the
But
decision.
we need to go to that.
Yes, of course.
It's not that way.
So, Ladyship is absolutely right that there was a modification of the argument and the grounds advanced in this case as the case progressed. But the change was to advance an additional ground to the effect that the appellant would be exposed to risk at the point of entry to the DRC, because at the time there was a country guidance case which indicated that if a person was subjected to prolonged questioning at the point of entry, they may be exposed to Article 3 ill treatment because of the conditions of detention. And the proposition that was being put and the amended additional ground was that because of her lack of capacity and because of her lack of lucidity, she would not be able to respond effectively to questioning and consequently would be potentially exposed to that extended examination and detention conditions. We deal with that first, just so that you have that point. There were submissions made to admit that additional argument, which appear in the supplementary bundle at page 59. They're dated from May 2023. And
But at some stage, I'd like the reference to the original decision letter.
I'm taking you to that now, Your Lordship. I just thought to assist
I
Her
misunderstood.
Ladyship. Paragraph 60, page 62, paragraph 18 of that new matter submission deals with what I've just described to Your Ladyship as being the additional ground. So far as the case was considered and engaged with by the respondent, this issue was always before. Although, as Your Lordship said, it became more compelling as the appellant's condition became more serious. So if the court could turn up the core bundle, page 161, which is the relevant aspect of the refusal letter from the Secretary of State, which dates from the 8th of October.
Again, please, Michael.
Yes, of course. So the refusal letter begins at page 145. It dates from 8th of October 2021. And
It's page 161.
161. Now, it's right to say that the assessment that was being performed here, you see at paragraph 106, was one that had been performed by reference to AM Zimbabwe.
I'm sorry, I've got the wrong reference. Can you just give me the reference again, please?
So
It's my fault.
it's the core bundle, page 161.
Right, sorry.
Paragraph 106.
Yes. In future, we'll perhaps put the bundles in different coloured folders. It would be easier to differentiate.
No, it's just
That
me.
would just confuse us.
It's just me being stupid. You know, there are only so many allowances you can make for me being stupid. Thank you.
So just at paragraph 106, Your Lordship pointed out, that's the reference there. There's an analysis in this decision letter about the application of AM Zimbabwe and the capacity of the appellant to fall within the Article 3 medical thresholds. It is right to say, as Your Lordship pointed out, that the medical conditions that were being considered at that point were not of the gravity that were before the First Tier Tribunal. And you see that at paragraph 108 over the page.
But 106 is almost a cut and paste from paragraph 183 of published opinion.
Essentially that, and it's, to be fair to the respondent, that's a fairly typical,
Yes, no, it must be a template.
yes. So there was this engagement, and
Well, that's presumably because having rejected the asylum claim, the Secretary of State then has to go through all the other possible potential bases on which the appellant could be entitled to leave to remain.
The ladyship is absolutely right. Although she does enjoy the facility, if she was so minded, to certify aspects of a claim, rather than the whole claim.
But the question perhaps only makes it clear. I didn't understand that at this stage, when the appellant made her asylum claim, she herself had advanced a claim based on Article 3 for medical reasons.
That is the case that she
Yes,
had,
right.
but
Okay.
the character of that claim, I accept, transformed significantly over the course of the life of the appeal because of the deterioration in the appellant's condition. So this was always an issue before the court, and there was an issue which the respondent engaged with, and the implication is that at least concluded that that first stage of a sufficiently substantial case being put had been met, hence the response articulated in that decision letter. We step back to the decision in Papua Villa and to page 536 of the authorities bundle. And really what we've just seen in the decision letter and what comes after the paragraphs we've looked at is the respondent engaging in the second stage of the process, which is described at page 1, paragraph 187 of Papua Villa. So here the court say, where such evidence, so where evidence capable of demonstrating there are substantial grounds for believing that there might be a breach, where that's been adduced, it's for the authorities of the returning state, this is paragraph 187, in the context of domestic procedures to dispel any doubts raised. The risk alleged must be subjected to close scrutiny.
So just pausing there, Mr. Jones, would you say that at the stage of the original decision letter, a strong prima facie case for breach of Article 3 on medical grounds had been advanced?
I would concede that the case advanced at that stage did not have the compelling character of that which was before the first hit.
Thank you.
Just to conclude that reference to the second stage, the court goes on in Papua Villa to observe that in the course of this exercise performed by the authorities, the fifth line from the bottom of that paragraph 187, course of which the authorities in the returning state must consider the foreseeable consequences of removal for the individual concerned in the receiving state in light of the general situation there and the individual's personal circumstances. And it goes on, the assessment of the risk, as defined above, must therefore take into consideration general sources such as reports from the World Health Organization or other reputable non-governmental organisations, which indeed is what happens in the refusal letter that we just looked at.
But in the present case, the difference in treatment that your client would experience as between the current regime and going back to the DRC is primarily in the care that she would be given by members of her own family. And so the submission must be that the way in which her relatives would care for her in the DRC is so different from the way that she's primarily cared for by PE here, that she would be in the position described in Papashvili in the test, serious, rapid, irreversible decline resulting in intense suffering or significant reduction in life expectancy. So that's one thing if we're comparing the health service of one state against another, and one is highly sophisticated and has got precisely the kit to keep someone alive on a life support system that patient might need. But here we're looking at how the family will react.
I concede it's, in a sense, it's a more subtle evaluative exercise that has to be performed, and one which isn't.
But there's got to be quite a strong evidential backdrop for a court to say, well, the family in the Congo would react in such a way as to cause their relative to decline to that degree that Article 3 is engaged.
I think that's the. I think that's part of the difficulty with the first-tier tribunals, if I may be so bold to say, that there was that focus on what will be available to her when she goes back, not enough focus on what the consequences of the loss of what she has had already will be on her health.
That's a comparison between what would be available compared to what, and then assessing the significance of it.
Yes, indeed.
But critical to that is to have sufficient evidence from the applicant as to what would be available from the family.
And I can see that the first-tier tribunal judge concluded that there wasn't, there hadn't been sufficient candour about the provision that would be available to the appellant on return, which also leaves a gap, which is problematic for us to fill. I concede that. However, that doesn't remove the reality that there was sufficient evidence, we will say, before the tribunal, both tribunals, to enable them to conclude that the consequences of the deprivation of those established care arrangements will be a manifest and significant deterioration in the applicant's condition. And the return, based on a person presenting with major neurocognitive disorder, to an environment where she has no established care arrangements, will be such as to itself cause a rapid deterioration. So however well-intended the carers might be in the DRC with regard to the assumption of care, their capacity to actually meet the needs of the appellant will be compromised by the fact on our submission that that her condition will either not enable her to embrace that care or will deteriorate to the point as a result of the loss of the stability and security that she enjoyed in the United Kingdom, to mean that she can't benefit from that care. And the breach will occur regardless of whether there are suitable carers in the country of origin.
So it's the loss of what she's got at the moment, no matter how good care is that she's going to receive, and the process of removal would cause the deterioration.
And also, Your Lordship, it's the time that it will take for any adjustment to be made, even assuming that care were comparable to that which the appellant enjoys in this country. The fact remains that her adaptation to that care, as the judge herself acknowledged in the first-tier tribunal decision, that there will be a period of disruption and distress, says that in respect of Article 8, but it equally is a proposition which applies to an evaluation of the Article 3 considerations. What the appellant will experience during that period of disruption and distress is itself based on the symptoms that we are aware of she presents with, based on the conditions that she is diagnosed to present with, based on her acknowledged lack of capacity, will be such to take her over the line, recalling again that this is an individualised evaluation and that what we're focusing on is the impact on this person.
Yeah.
So that's
helpful, thank you.
just stepping back into Paposhvili again for a moment, then to look at the third stage, and what we say is quite a crucial stage in answering the concern that Your Lordship flagged about how is care embraced within treatment. Paragraph 188, the court says this: as the court has observed above, this is again page 536 of the authorities bundle, what is in issue here is the negative obligation not to expose persons to a risk of ill treatment prescribed by Article 3. It follows that the impact of removal on the person concerned must be assessed by comparing his or her state of health prior to removal and how it would evolve after the transfer to the receiving state. So that is essentially the submission that I've just made.
What about 189?
I'm coming on to that, Lordship, yes.
But just pausing on this passage, was there any material in Dr. Heckey's report that dealt with this specific question?
Yes, Your Ladyship. On our submission there was, although the Upper Tribunal didn't agree with us.
Right. Did Dr. Heckey anywhere say she's got such a close relationship with PE, her primary carer, that if she was separated from PE, she would rapidly and irreversibly, whatever the test is, that the test would be met? Is that what did Dr. Heckey say that?
Well, as you'd expect, Your Ladyship, I don't think Dr. Heckey uses that language because that might be perceived to be a kind of encroachment on the exercise that would fall to be performed by the court.
I think the law's moved on from that.
Well, maybe it hadn't moved on in 2022 when this was written. I don't know. I defer to Your Lordship. I don't know.
Are you able to take us to an example of Dr. Heckey?
I can take you to it now.
Something that fits that. But I think
I'll take you to it now if it's convenient. If that's a convenient point to do it. We say that the reference in the first of Dr. Heckey's report, which appears at page 119 of the supplementary bundle, paragraph 5.4.2 does precisely what the Ladyship seeks.
paragraph.
Top of that page, 119, Your Lordship. So essentially, this is the expert. If you look over the page to 118, this is the expert responding to the specific questions put by the appellant solicitor, and the question that she's responding to here is this.
Yes.
Page 118 in the supplemental bundle.
Yes, I was in the wrong bundle.
Please comment on the appellant's prognosis. Please comment on any effect. This is 118, Your Lordship, of the supplementary bundle.
Thank you.
Is this the first report?
Yes, Your Lordship. So the question, first of all, at page 118, please comment on the appellant's prognosis. Please comment on any effect on this should she not receive recommended treatment support in the future.
So this is in 2022, October.
That's correct, Your Lordship.
Page 102.
And we
I
say
see that question being relevant if you were thinking about Article 8.
it's relevant to both, Your Lordship.
Yeah, well, it depends how you put the test. But do we see any language there which reflects the test as amended in Pappas-Filly? Just ask about the prognosis.
That may be a deficiency in the way that the questions are put to the expert, Your Lordship. I'm not sure that, I don't have the letter of instruction, unfortunately, so I don't know whether the inquiry was framed by reference to the Article 3 test. But all I can indicate, Your Lordship, is that a reading of this paragraph enables a conclusion that the findings here are capable of meeting that test on one reasonable view. So this is what the expert says, and it's important to understand.
Are you putting it no higher than that? So you're saying capable of meeting the test on one reasonable view?
At that point, Your Ladyship.
Right.
But we progress from that point to the advancement into the more serious
Right.
stage of the appellant's condition the subsequent year.
Kind.
Indeed.
So
And
you
so
might expect this issue to be revisited in the second report, but this is, on your case, the best reference
this is
to rely upon in the context of Article 3.
it's the first reference,
Oh,
Your Lordship.
I thought
I
it-
apologise.
Maybe I misheard.
It's the reading two references together.
Yeah,
They are the
okay,
best
sorry.
So
references.
we were turning up
Yes.
this report on this page 119,
Yes.
I think, to look at paragraph 5.4.2 as an
Correct.
example of Dr. Hecky advising that there would be a deterioration. And is it the last sentence of 5.4.2? Should she not receive her current level of support, I believe her functioning will deteriorate rapidly, and she is hence very vulnerable.
Indeed, Your Lordship.
Its current level of support, rather than particularly being separated from PE and being removed to the other country.
And it's functioning.
One has to read, I mean, one reads that together with what precedes it, of course, and what the paragraph begins with is, in my opinion, without the support of her daughter, P, Annie's quality of, the appellant's quality of life would be severely compromised.
Yes, but you read the paragraph as a whole, and what's being referred to is the current level of support, not the identity of the supporter. And the premise of all of this is that she's going to get no support in the DRC.
Well, respectfully, that's not how I read paragraph 5.4.2. The expert is not there saying this level of support.
First-tier tribunal, I think, held that admirable, and clearly the human situation here of this lady and the care she gets from her daughter are readily understandable. But the finding of the first-tier tribunal, I think I'm right, is that there was nothing special about he and her capability of providing care. She was a kind, very caring daughter, but she wasn't medically skilled or in some way unique as a potential family carer. That's right, isn't it?
I think, yes, I think the language she used was there wasn't specialised care that nobody else could provide.
I took that to mean.
Yeah.
And indeed, there were occasions on the facts when PE didn't provide the care because her own health was compromised, and so there were occasions when another sister looked after the appellant.
That's correct. But that sister significantly falling within the close committed family unit which the first-tier tribunal judge accepted existed. So
Yes.
what you had was a closed family unit of people who were mutually dependent on one another, supporting the appellant and managing her, principal amongst whom was PE.
Yeah, and they know her current level of functioning, her current needs. They're used to understanding how those are provided on a daily, hourly basis, and so it works here.
Precisely, Your Lordship. So this is the starting point, which is essentially an emphasis on the role of PE in the extension of care and the risk of severe compromise to the appellant in the event that that care, we say, is removed. And then, as Your Lordship pointed out, the expert, having moved through the factors which would, in fact, I will read this to you if I may, just very quickly. In my opinion, without the support of the daughter, Annie's quality of life would be severely compromised. She cannot, since the strokes, care for herself and live independently. She becomes very stressed at how compromised her functioning has become. Despite her current memory difficulties, she has insight into the very significant changes that have occurred already, contributes to depression, as I've already described. Hence, the combination of significant cognitive, physical, and mood-related problems, in my opinion, means that her prognosis is poor, as it is unlikely she'll regain her previous level of functioning given the damage caused by the strokes, but she would remain stable. She can have improved quality of life with her family. The stress and anxieties related to immigration is resolved. Now that's critical, because what's being said is there is a possibility for stabilisation if the stability that she has, as described in this report, is retained. That's not what's being proposed by the respondent. What's being proposed by the respondent, however one looks at it, is subjecting the appellant to a relatively extraordinary departure from these established and settled relationships and arrangements. So taking it to the point that the prediction about the absence of cognitive decline falls away if that stability falls away. And indeed what we see anyway, as I'll take you to in a moment, is that the appellant deteriorates rapidly regardless. So what the observations made here, they're critical because they're describing the consequences. The consequences effectively of what removal will bring. What the return, even to a caring environment, will not resolve because it is the removal from the stability and certainty.
But she's not saying the return even to a caring environment because her assumption is that she won't get any care.
But Ladyship,
so she's not dealing with the hypothesis that she'll go back to the DRC and will get care from other family members in the DRC. As I read this bit of Dr. Hager's report, she's not contemplating that possibility at all.
Respectfully, she's not having to contemplate that because
it doesn't matter
the
whether
consequences.
She's got to or she hasn't got to. She's not dealing with it.
She does deal with that in subsequent paragraphs. She deals with that at paragraph 5.4.3 and 5.4.4. But this is her opening observation about the importance of the retention and maintenance of the existing care arrangements to the appellant's state of health and to the avoidance of a deterioration in that state of health. She then goes on to talk about the likely compounding consequences, specifically of other particular events, such as a return to environment where the appellant perceives that she's at risk.
Yeah.
But in the first sentence of 543, the words "with no access to this support," is her opinion based on the assumption that there will be no support in the Congo?
This is I think what subsequently follows is first an analysis of the expert's understanding of the adequacy of medical treatment for the conditions with which the appellant presents. And then what you have in the subsequent paragraph 5.4.4, analysis of what the expert understands to be the potentially available.
The expert there deals with the grandsons and the appropriateness. He doesn't deal with the sister.
No. She deals with what's...
My question, which follows on from my lady's question, would it be fair to read these paragraphs, taking them as a whole, looking at the beginning of 543, as an assumption that there would be no support?
It is fair to read these paragraphs we submit as each as an adjunct to the next.
No doubt.
And the reference to further at paragraph 5.4.3 is an indication that should these other circumstances manifest, they will exacerbate the condition and risk which has already been identified at 5.4.2 with regard to the loss of the current care arrangements. So they don't render irrelevant the observations the expert has already made. They essentially develop the quality of the risk. And it is relevantly these latter aspects of the expert's opinion that the first-tier tribunal judge takes issue with, and indeed records findings which compromise. She finds that there is no risk in the country from the state. She finds that there would be, or she finds she's not able to conclude there wouldn't be suitable carers available. But that doesn't rob what she's already said about the importance of the existing care arrangements, the maintenance of the appellant's level of functioning, of its value and importance to the exercise that the judge has to perform. And it's a significant feature of the first-tier tribunal's determination that she actually alludes to this paragraph in her judgment, but then doesn't engage with it in her conclusions. And I'll just very quickly turn that up for you. The first-tier tribunal judge's decision begins at page 99. It's a lengthy decision. And the judge deals with Article 3, the health case, beginning at paragraph 218 on page 134. And if you note paragraph 222, which begins at the bottom of page 134, the last 6 or 7 lines, the judge is referring to an aspect of Dr. Heke's report. In fact, if we take it from the word nonetheless, which is about 4 lines from the top. In fact, no, step on to the next sentence. Dr. Heke opines, do you have that?
Yeah.
Dr. Heke opines that due to the appellant's inability to fend for herself and not have the support of PE to attend to her care needs will lead to a further significant deterioration in her mental health. So the observation is made clearly there that an aspect of the expert's opinion is that relationship with PE and the loss of that relationship will lead to a deterioration in health. And the judge is recognising that.
That's not. We went to the paragraph in the report. I read that paragraph as saying that if you took away the support, whoever's providing it, she would decline. It's not the finding that it's particular to PE and that only PE in the whole world could provide that support.
I mean,
There's no reference to the emotional element that you're describing.
That is the challenge that I have, is
Yes.
to try and persuade you that that is in fact how
Right.
this evidence should be read, or at least is capable of being read.
Yes.
I mean, the judge, as I said, has articulated that position. We say, as I'll
But
seek to,
it's ambiguous, that sentence.
but the judge doesn't say that, Your Ladyship. The judge simply sets it out.
Exactly, it's an ambiguous sentence. So the judge might be accepting the spin you're putting on what Dr. Heggie said, or she might not.
But surely, Your Ladyship, she has to say that. Because what the expert is saying here
Well,
is...
because she's considering the facts as they are, and the facts as they are is that the support she has in the UK is from PE.
And the absence of that support, in combination with the challenge that the appellant has in living independently, will lead to a deterioration. That's what's being said.
If she has no support.
Well, the baseline of the sentence is that the appellant's inability to fend for herself. So if she doesn't have support, she can't fend for herself, she will decline.
It is. I appreciate that it's... I mean, this is the way the judge has approached the analysis, but what I extract from this, which is significant, is that she is acknowledging an aspect of Dr. Heke's evidence.
Yes.
Speaks to the importance of that relationship.
You're right about that.
And just to kind of follow through on the point I made earlier, when one gets to the final kind of analysis of the judge at page 232 and page 137, paragraph 232 and 233, there is no engagement with that aspect of Dr. Heke's evidence. It is effectively the position fixed on...
Sorry, which paragraph again, please?
I beg your pardon. It's
132.
page 137, paragraph 232 and 233.
My fault for being several skips behind the beat.
I don't think you are. I'm amazed I'm on top of this at all. So there the judge is analysing. I don't need to take you to it, but the nub of it is that The judge has concerns about causation for deterioration in the appellant's condition. She's expressing the view that having rejected the protection claim, the appellant's expression of fears no longer bear on an evaluation of how she may respond to a return. And then she goes on to speak at 233 about the inadequacy of evidence with
But the
regard to other
important
families.
point made by the FTT, which conditioned the FTT's view of Dr. Hickey's opinion, is in the last sentence. Dr. Hickey's view is also based on her understanding and acceptance of the appellant's account. She will have no support in the DRC, which I also do not accept.
Well, that's the way the judge has interpreted the evidence. That's not the way we say that evidence falls to be read. That's not
what evidence falls to be read?
Dr. Hickey's evidence is not fixed exclusively on the
I see.
proposition.
So your submission about 13232 is that the FTT's misinterpreted Dr. Hickey's report on that point.
Well, she's interpreted it correctly on the preceding page, but she then hasn't factored in that interpretation to her subsequent evaluation.
So the ambiguous sentence is the interpretation. And the core of that is, there may have been something in the oral evidence, but the core of that is paragraph 5.4.2. Right.
But that, as I indicated to your lordship, that paragraph in the initial Hecke report falls to be read then with a paragraph in the subsequent report following the...
Just before we leave, forgive me,
Sorry.
you took us to 232, but also 233. Isn't that reflecting earlier findings that she's made? She's heard from some of the relatives live evidence in the hearing before her, and she's saying that they don't really address the level of help that would be provided by the family in DRC.
Yes, your lordship, that's exactly.
And indeed, we were invited to look at page 52 of the supplemental bundle, which is part of the transcript of the hearing. And I have to say, subject to what you say, that gave me the impression that the submissions made on behalf of the appellant actually, at the bottom of that page, accorded with that understanding.
Well, again, I will try and persuade you that there is an alternative interpretation, but ultimately, as Ms. Capel acknowledged in her statement, it falls to your lordship to make a judgment.
Because that's why I asked you to address 189 of Pashvili, because it's not it's simply a comparative exercise between what would happen in DRC and what is happening currently in this country, because there's no obligation under ECHR for this country to maintain that level. The question is whether the level which would be provided, for the sake of argument, shall we assume support is included as well as medical treatment, whether that level would conflict with the standard required by Article 3.
Agreed.
Which is why these cases truly fall, normally speaking, within Article 8.
But
the question is, what is the treatment that will be available? Would the treatment that will be available in the receiving country fall below the standard required by Article 3?
That's and
there seems to be a gap in the case as to what would happen in DRC, and the evidence really had to come from the family. Is that unfair?
I think that certainly the well, obviously, if there had been evidence that established that the family in DRC was incapable of providing any form of care or care which was capable of lifting the appellant over the threshold, then that would be likely determinative, assuming that that was accepted to be credible. We don't have that evidence, and the judge, I accept that the judge has permissibly evaluated this case by reference to that shortcoming. But that, as I've said already, that doesn't remove the necessity to actually engage with the appellant's condition and the consequences for her generally of exposure to this change of circumstance, this significant change of circumstance. And if I just follow through on that point to go to Dr. Hecke's second report. Just a moment to get the right paragraph. It's page 148. This is the report from April of 2023. Top of that page, paragraph 5.2.1. the critical aspects of that paragraph is, in my opinion, since my last assessment in 2022, Annie's level of support needs have only increased. She's now entirely dependent on her daughter, with the additional support of her extended family in the UK, in particular when primary carer is struggling with her own severe physical health problems. In my opinion, the appellant cannot function independently in regards to meeting her basic living needs or adhering to current treatment regime. She needs repeated prompting. I do not believe she has the capacity to fend for herself independently on any level. I will not repeat her current medication. And then she concludes that paragraph by saying, however, the appellant clearly requires regularised and consistent support on a practical and emotional basis. So again, there's that emphasis, consistent with what was said in the preceding report at 5.4.2, about the significance of her primary carer and the role of that individual in the maintenance of the appellant's well-being, and also the importance of consistency and regularity of support. And this is all...
That latter point is right, but I'm afraid my reading of that paragraph is borne out by the final sentence, which doesn't mention her daughter in particular. She says, and it's plain, awfully, because of the condition by then that your client was in, she clearly requires regularised, consistent support on a practical and emotional basis, full stop. It doesn't say she has to have PE support.
That is true, but I think the point I derive from that is, first, the entrance into that paragraph is placing emphasis on the existing support that's provided, and then the emphasis at the conclusion of that paragraph is that the infliction of a significant, material change on those current care arrangements will have consequences in the context of an individual who is already at that point rapidly deteriorating.
But it's the same ambiguity as we noticed before. I would read it simply as she's now entirely dependent on her daughter, P, open brackets, who happens to be the person who's providing the support. Because Dr. Hickey doesn't clearly say, and it's a dependence on her in particular, rather than just simply saying she needs the support, and the support happens to be being provided currently by PE.
I think it's less ambiguous than
Yes.
So that's why, I mean,
afraid, but-
you've asked me for highlights, so
Yes,
I've
I'm
endeavoured
afraid
to
that
give you
those are the highlights.
some
they are the
highlights, but the difficulty with giving highlights is that you're then reading observations in
Yes.
isolation.
Yeah.
And what one has to do then is reflect on the particulars of that paragraph against what precedes it.
Yeah.
And we say that one particular observation that bears is that those last couple of words, the importance of consistency and regularity with regard to practical and emotional support. Now that is,
and it must. I'm saying it must be the case that the move of an individual in the position of your client back to the Congo, she's likely to be bewildered because of her lack of capacity, and it's a complete change of the regime that she's been comfortable with, will be bound to have a negative impact. So
Yes.
all of that, I think, is something that we'd all understand. That's not necessarily getting you over the Article 3. But it's obviously part of the picture, and it'd be wrong to think it wasn't.
I think with respect, it might get us over, it should get us over the threshold that this was an issue that had to be determined and hasn't been determined.
If it was raised.
Well, would it? Because I keep noticing the way you're putting your submissions, and you haven't yet submitted that these passages can only be read in one way, and that a reasonable FTT reading them could only have concluded that support provided by the particular individual was in some way essential to the appellant's well-being. And if you're not submitting that that's the only way of reading these passages, and if you're accepting they're ambiguous, I just don't see how they help to show that the FTT erred in law.
So I think we place emphasis on the existing care network because we must, because that is the platform that gives the appellant stability. But the significance of it is not that this care couldn't potentially be provided by somebody else, but there will be material, significant consequence of our submission for that move when it's effected. That the consequence of that move will be of such moment to the appellant as to be capable of taking her over the threshold, regardless of what she will meet when she gets back to the DRC.
That isn't clearly expressed in either of the two passages you've taken us to.
It is the implication relationship is clearly there. My respectful submission.
It's a lurking implication. How can it be Robinson obvious?
Well, it's Robinson obvious when it's read with the argument and issues as they're presented as a whole, as opposed to, again, focusing in on one aspect of the expert evidence. It's Malone and Friend that says that Robinson obvious doesn't work here because the expert evidence doesn't speak to the issue. We say it does, albeit you may conclude not so as to be decisive, but when it's read with other aspects of the submissions and considered in the context of the legal framework.
Obvious point. It's a point that jumps out from reading the papers. It's not a point that has to be constructed from elusive passages in two different experts' reports.
Perhaps if I could put it this way, Your Ladyship, if just consider this scenario. It is the scenario we're concerned with. You're presented with a person who lacks capacity, who suffers from major neurodegenerative condition, who lacks lucidity, who suffers from significant memory problems, who struggles, as is described in Dr. Heke's report, to remember the days of the week or the weeks of the month, doesn't recognise the environment she's in at the time an assessment is being performed. She mistakes the house she's in for the daughter she lives with principally, for that of the daughter she visits occasionally. That is the presentation of the individual. And what is being proposed is that individual be plucked up from this secure environment where she has stability and emotional support and practical care and removed back to another environment where Dr. Heke is also saying she has progressively less capacity to recall the past events. So she's going back to an environment which her familiarity with which potentially will be compromised by this degenerative condition. In combination with that degenerative condition, she presents with comorbidities of depression and anxiety. And in combination with that principal degeneration, the prediction is any significant stressful event is likely to accelerate the degeneration and exacerbate the pre-existing mental health conditions.
I follow that.
So,
But if we're going back to the case law in Article 3, you could have a case where removing somebody from this country in the condition they're in could lead to their death. Secondly, you could have a case where there could be, following on from Papashvili, a reduced life expectancy. In either case, you would expect expert evidence to say as much. We're not dealing with either of those two situations. We're dealing with the third category, where there's a likelihood of intense suffering.
which is why I took your lordship
But
to
you would
those.
still expect someone to say that, and isn't an essential part of the analysis that any one of those three consequences could come about because of the treatment that would be provided in the receiving country. And in this case, it's essential to know what would that treatment be, not just the medical treatment, but the care. Are they all essential ingredients of the Article 3 analysis? And not necessarily, some of them are alternatives, obviously. Not all are risk of death cases, but will reduce life expectancy. But there are essential elements which have to be dealt with by the applicant.
As I said already, your lordship, it would certainly be easier for the appellant to succeed in this case if there was clearer evidence about what she would be going back to. And if that evidence...
If those elements aren't present, it raises the question, should Article 3 be raised at all?
Well, to be fair to the way the case was put, obviously, well, perhaps it should have been predicted, but perhaps there wasn't a prediction that the protection claim was going to fail, or that the findings of fact with regard to a lack of candour about family circumstances were going to be recorded. I mean, it's a lot easier to...
Yeah, so you're in difficulty.
With the gift of hindsight.
If the case is their family is spread to the four winds, she doesn't know where they are, and then the judge disbelieves that, there's no evidence of what would be provided because it just wasn't part of the case. And so you're stuck in a way with that.
And Your Lordship is right that it would certainly be an easier task for me to persuade you that there was, a case capable of getting the appellant over the threshold if we had both components, which was, certainty as to to questions over the adequacy of support at the point of return, as well as the point that I'm relying upon, which is the consequences of the loss of the existing care arrangements and what implications that will have.
That's a realistic position. So where are we going now? We have interfered with your.
I'll find my way back.
A number of times.
Not at all. It's better we're focused in what we're dealing with. And I hope.
And it is. I find it helpful. So where would you like us to go now?
Well, very briefly. So we've removed ourselves from it for some while. Just the last element of Patrick Villi, because your ladyship said at the beginning, I think it's important that the whole of that evaluative exercise that's required there be in the minds of the court when it's making its decision. And so we go all the way back to the authorities bundle at page 537.
Yes.
And so we've just seen the point on which I place particular emphasis, which is that it's the impact of removal on a person must be assessed by comparing his or her state of health prior to removal and how it would evolve after the transfer. That's significant. That's really the focus of my submission. And then the final aspect of this process, which the Grand Chamber describes at paragraph 189, as regards the factors to be taken into consideration, authorities in the returning state must verify on a case-by-case basis whether the care generally available in the state is sufficient and appropriate in practice for the treatment of the appellant's illness so as to prevent him or her being exposed to treatment contrary to Article 3, which is, Your Lordship's, the other aspect of the test with which obviously I'm going to struggle given the findings that are recorded about the uncertainties what care provision will actually exist.
But this is significant in relation to the point that my Lord Justice Holgate raised with you, because what's being said in 189 is the care generally available in the receiving stage is sufficient and appropriate in practice for the treatment of the applicant's illness. Now that very strongly suggests to me that what the court has in mind is medical treatment, not care and support.
And happily,
comment on that?
Yes, it's an opportune moment to go and answer the question I was asked about half an hour ago. So this is, as you would expect, the way that the test is formulated by Appellant is to an extent influenced by the facts that it's being confronted with.
Right.
But beneficially, we have a subsequent decision from the Grand Chamber in the case of Savran and Denmark, which appears in the authorities fund at paragraph tabs 26.
I've got Savran at 25.
Oh.
So have I.
Oh, you're quite right. I do apologise. See, I'm now becoming
Enormous decision. 90.
Yes.
98
Fortunately,
pages in the
Your Lordship
report.
only taking to a very small part of it.
Yes. Good.
Obviously, want to read it all at your leisure, but
Possibly not.
if I can just take you to, so the proposition we advance essentially, effectively in response to the not unreasonable submission made by my own friend for the respondent, that the treatment, the language of Paposhvili doesn't apparently lend itself to the evaluation that we're encouraging. Savran, we say, answers that, because if you look at the judgment, this is a case concerning a person presenting with serious mental health issues. I think, if I recall correctly, it was schizophrenia.
Paranoid schizophrenia,
Yeah.
paragraph 3.
Yes. So, if I could ask you to turn up page 594.
Thank you.
Look at paragraph 137. The court says this, that under the heading relevance of the Paposhvili threshold test in the context of removal of mentally ill aliens. The court has consistently applied the same principles in cases concerning the expulsion of seriously ill applicants, irrespective of the type of medical issue, somatic or mental, which underlay their health condition. Appellant judgment, before it proceeded to formulate the new standard, the court had regard to case law relating to the applicant suffering from both physical and mental illness. And goes on, in the wording in paragraph 183 of Appellant, the standard refers to seriously ill persons without specifying the type of illness. Thus, it is not limited to any specific category of illness, let alone physical ones, but may extend to any category, including mental illness, provided that the situation of the ill person concerned is covered by the Passage Villi criteria. And then it goes on at 138. In particular, it is relevant part of the threshold established in paragraph 183 of the Passage Villi judgment, rather than mentioning any particular disease, broadly refers to the irreversibility, the decline of state of health, a wider concept that is capable of encompassing a multitude of factors, including direct effects of illness as well as the more remote consequences. And this is where we say the language of the court lends itself to the consideration of impacts on care regimes, for instance. Moreover, it would be wrong to dissociate the various fragments of the test from each other, given that, as noted in paragraph 134 above, a decline in health is linked to intense suffering. It is on this basis, of all of the elements taken together and viewed as a whole, the assessment of a particular case should be made. So there is no, obstacle to this test being applied to the appellant's circumstances. And to make that case, again, if I could ask you to...
Anyone suggesting the test can't be applied to a case involving mental as opposed to physical illness. But the point I was making was, doesn't the test appear to be talking about medical treatment rather than care or
That
support?
was my Lord's question as well.
And yes, exactly.
Well, actually, the language of paragraph 183 of Passage Villi is to appropriate treatment. It doesn't, the wording is not medical or therapeutic or anything of that nature. It's appropriate treatment.
Let's go back to it.
These two paragraphs don't help us on whether it's treatment or care. They're to do with the illness or the cause of the person becoming a seriously ill person.
We respectfully submit.
Can be physical, can be mental.
We say it does, respectfully, it does help you, because what it does is it puts the focus on the condition and on the severity of impact.
Yes.
And then the evaluation has to be on what factors then may operate so as to impact that condition.
To ameliorate it.
And
yes.
So it doesn't matter whether it be a form of medication or whether in the context of psychiatric case, whether it be psychiatric intervention by a psychologist or therapy. What matters is that there is a serious condition that will be affected by treatment, which is the removal. And then one has to evaluate what are the considerations which are capable of ameliorating or currently ameliorate that serious harm, which may not be available if that individual is returned as is proposed. And in this instance, the factors that impact on that are the extension of care.
Well,
And-
that's why the question started, because of the ground of appeal to the Upper Tribunal, paragraph 12, talking about the removal of the existing care per se. I can understand how care is integrated with medical treatment, perhaps, in some cases, but the way it was put to the Upper Tribunal was care as a freestanding aspect.
I think it's, I suppose one response to that is that this case is, in fact, a hybrid, isn't it? This is a case which is concerned not only with care with regard to the management of a neurodegenerative condition, it's also a case that is concerned with care with regard to the management of a major depression and anxiety, and care which is extended with regard to the management of hypertension for a person who's presented with a series of strokes. So what you have is actually a series of basically different dimensions of healthcare incorporated into a single circumstance. And the critical point about care is that the care that's extended here enables the management of all of those different conditions. So it operates on a variety of different levels in a variety of different ways. And so it may not be specialised care in the sense that the first tier tribunal judge uses the term of a consultant, a consultant cardiologist, for example, managing a serious heart condition. But it is specialised in respect of this individual. it is particular to her, and it enables the management of this panoply of different conditions, all of which, or any of which, are capable actually, if they deteriorate, of causing her serious harm. And all of which are predicted as likely to deteriorate in the presence of exposure to serious stress. And that's not, I mean, Dr. Heckett says it, but really with respect, it is a matter of common sense. When you have a series of stress-related conditions which are obviously impacted by stress, stroke being one of them, but also neurodegenerative conditions are impacted by the exposure to change and to stressful situations, as is serious mental health problems, particularly where the anxiety is linked to the event which it is proposed the person be exposed to. So we say that the reading Sabran and Papashvili together, there is no difficulty with translating the approach to care in a case like this. And just to extend that proposition further, if you could look at the case of Ante again, which we looked at earlier, although very briefly, at tab 14 of the authorities bundle. What you find there, and this is just to sort of give you a summary of the case, it is a case concerning removal to Somalia, where one of the contentions being advanced by the appellant was that he would be exposed to inhuman and degrading conditions by virtue of being forced to live in conditions of extreme material deprivation. So this was specifically by reference, I think, to the kind of slum housing that he might find himself forced to reside in. And in that case, the tribunal, at page, if we could turn up page 261, responding to the respondent's contention that the Papashvili test couldn't be applied to instances of naturally occurring events like that, material deprivation, the tribunal rejected that submission. Look at page 1261. I mean, everything that precedes it, the analysis really commences from, I think, principally from paragraph 56, but I think it's probably just helpful for now to give you the headline. Paragraph 61, the tribunal say this: consequently, we cannot agree that there is any jurisprudential distinction between health cases and those concerned with material deprivation. There is no doubt, for this reason, that none of the authorities to which we've been referred have drawn one. To the contrary, the courts have treated them in the same way, uniformly applying the N test wherever the feared harm arises from naturally occurring circumstances. Thus, we will accept, paragraph 62, we accept that the Convention has expanded and that each incremental spurt of growth must be carefully considered. We do not accept that in the applying Papashvili to this case would be materially or impermissibly be adding to that growth. It would simply be adding to the law within its existing limits. N threshold has been modified by Papashvili and AM Zimbabwe. It is no less exacting, but nevertheless very high test that we must apply, and we are no longer concerned with whether there is any imminent risk of death upon return to Somalia, but rather whether they'll be exposed to conditions resulting in intense suffering or to significant reduction in life expectancy, such as humanitarian case.
I'm not following this. That's restating the Papashvili tests in a different way.
It's applying
the same
to-
point. But it seems the point of this case is it was applying them to the circumstances of that case.
And that is all we're
How
saying,
does that help this case?
because our basic proposition is that that test is obviously equally applicable to cases like this.
But there's
Which
no doubt
indeed
about what the test
is-
is and nor its applicability. But does the application of that test in that case help us in the present case?
In the sense of, does it get us over the line in terms of, well, that's a different point, really,
Yeah,
Your
okay.
Worship. The point I was meeting was that, was there a barrier to the application of that test at all because of the nature of the appellant's case relates to care as opposed to treatment? And the simple answer is no, it doesn't. It doesn't matter. What matters is that there will be serious consequences which will impact on our case so as to cause irreversible harm. And the nature of the condition and the factors that enable the management of that condition are are what matter, and whether or not that condition will be affected by the exercise which the respondent is proposing to expose the appellant to, by reason, on the limited submission I can make,
So
of the loss of existing.
Sorry if I missed it. What was the circumstance going beyond a medical condition and treatment that was relevant in that case?
This case was not about
This wasn't a medical case
care
at all.
No.
It was about the contention, I think, was that the conditions in which the appellant would be forced to reside would basically be these naturally occurring conditions in shanty accommodation, where I think there was vulnerability from criminal gangs and so forth, would expose the individual to serious irreversible harm. And so it was a kind of, the significance of it is that the translation of that Papage-Villi test to other forms of naturally occurring conditions beyond medical and healthcare cases. I did, with the diligence of my junior, search to ensure that there'd not been any subsequent observation on the correctness of the ante-judgment in this respect, and we identified nothing.
Thank you.
Indeed, I think it was cited with approval in one case, or yeah, although maybe not on that particular point.
Sorry, it was cited with approval on that point in another case.
No, I don't think. Forgive me. No, I don't think it was cited with approval on that point.
And it wouldn't have been subject to an appeal because the Upper Tribunal found against the appellant on the facts, regardless of the test they applied.
I don't think that's ever held back an appellant from appealing. In my experience, indeed,
Does
here we
comment
are.
on your case.
Here we are.
All right.
But I shouldn't laugh. It's too serious a matter for that. But yeah, no, there was no onward appeal. But certainly the respondent wouldn't have.
Well, the respondent
Couldn't have appealed it.
Yeah,
So.
exactly.
Yes.
I suppose the last reference to just on that care point was really to a very old case, the case of D in the UK. But I'm not sure really that progresses things any further than I've taken it with regard to the extension of the test to care as opposed to treatment. So I think we'll march on.
Faintly archaeological bit about it. It's sufficient based on
I really we don't want to go all the way back to D, because I mean that was a very unpromising starting point from which these health cases took off. Although I do understand that Mr. D did last for quite a significant amount of time after that judgment, happily. So his treatment.
97.
So, Your Lordship, Your Ladyship, that's just those references are to respond to that particular point. And just to go back, we've looked at the Papage-Villi test now, and you've heard what I've had to say about how that operates in respect of this individual, and there are other references that might assist the tribunal just with regard to the individualised assessment that's required. But I don't think that proposition is controversial. And we've looked at the critical one already in Savran with regard to the necessity of assessing, for example, severity of impact by reference to the individual circumstances. So I'm going to move on.
Yes.
Just to make a couple of final observations with regard to how one evaluates Article 3 medical cases and what sorts of considerations impact, which really go to the principal submission that we've been concerned with, which relates to how the loss of current care regime may impact on the appellant's presentation on return. So the first case, just to turn up again very briefly, is the case of Savran. Once more, tab 25.
Which page?
I beg your pardon, Judge. Page 595.
Thank you. Just beyond where we were.
This is a very brief point, but perhaps nonetheless a significant one in support of the proposition we make, which is that a relevant consideration in an assessment of this sort is obviously the ability of an individual to process and manage the consequences of return with regard to the access to treatment or care. And just this point made very briefly as to the obvious relevance of that, paragraph 142, the court makes an observation with regard to this man presenting with paranoid schizophrenia. The court observes that the medical evidence submitted by the applicant showed, in particular, he was aware of his disease, clearly acknowledged his need for therapy and was cooperative, and then went on to describe the sorts of treatment that he'd be able to access. And so that it was recognised to be an important precursor to the evaluation of the ability to access appropriate treatment, that an individual was capable of actually engaging with that process and would be willing and able to do so.
I don't think that's what they're saying at all. They're just making an observation about the fact. They're not enunciating a test.
It's not a test, but the point I'm making is it's recognised to be a relevant consideration. If they had concluded, for example, that Mr. Savran had a history of failing to take his medication, had a history of failing to cooperate with therapeutic care, then the evaluation they would subsequently perform would be different, and potentially the outcome might have been different. But so
I'm sorry, I'm just not following how this.
It's a light point, but it's one I make nonetheless. I think I say it's significant to the exercise, the obvious exercise that forced to be performed here. The second point I make.
But just before you leave 142, the context seems to be 140, which the end of it says, as noted in 135 above, it's only after the Papashvili test is met that any other questions, such as availability and accessibility of appropriate treatment, become irrelevant. So if you go back to 135, that takes you back to 134, which is the test which an applicant has to satisfy.
Yeah.
Before you get onto these issues.
Yes. But that's still, it's still a relevant part of the exercise, regardless of what point in the process one is looking at. If you're knocked out at the first stage, if you're knocked out at the first stage because it's concluded that actually the allegation is not sufficiently serious with regard to the harm that you'll be.
Evidence.
Yes, but we say that's not this case. I've drawn what I can from that. I'll move on. We could just then turn up the case of Y Sri Lanka, which is a decision from this court at tab 9. To an extent, it's to the same point with regard to the kind of the response of an individual to the return to the country of origin, not as with Savran to the ability or willingness to access treatment, but in this instance, the ability of the individual to process and rationalise the absence of a risk. And so Y Sri Lanka was a case concerning a brother and sister from Sri Lanka who had been exposed to torture and who had also been exposed to and witnessed the death of family members. And their case was fixed on a more familiar argument as to their mental health being such that they would be a risk of suicide were they to return. Now, the test that was applied but was varied in Y is that set down in a case called J, which is set out at paragraph 6 of the judgment on page 133. And the relevant part of the test, for our purposes, appears at paragraph over the page in the indented paragraph 30. So the fifth element of the test, having progressed through more familiar territory of seriousness of illness and so forth, so the test as formulated by Lord Dyson was, fifthly, in deciding whether there's a real risk of a breach of Article 3 in the suicide case, the question of importance is whether the applicant's fear of ill treatment receiving state upon which the risk of suicide is said to be based is objectively well-founded. If the fear is not well-founded, that will tend to weigh against there being a real risk that the removal will be in breach of Article 3. And the proposition that was put to the court is outlined at paragraph 7 below. It said the second and third sentence, the broad contention is that notwithstanding the emphasis in the fifth proposition in J on the fear of being well-founded, a fear of renewed torture and sexual abuse may sometimes be just as real and its potential consequences just as grave, and there is no longer a foundation for it. And then over the page, on page 136, paragraph 14, the relevant bit being under the indented paragraph, Lord Justice Sedley, giving the judgment of the court, said this: if a fear of ill treatment on return is well founded, this will ordinarily mean that refoulement or return, if it's a human rights case, cannot take place in any event. In such a case, the question whether the return will precipitate suicide is academic, but the principle leaves an unfilled space for cases like the present one, where a fear of ill treatment on return, albeit held to be objectively without foundation, is subjectively not only real but overwhelming. There is no necessary tension between the two things. The corollary of the final sentence of 30 of J is that the absence of an objective foundation for fear, and some independent basis for it must be established if weight to be given to it. Such an independent basis may lie in trauma inflicted in the past on the appellant, or as here, the receiving state, by the receiving state. Someone who has been tortured and raped by his or her captors may be terrified of returning to the place where it happened, especially the same authorities are in charge and notwithstanding that the objective risk of recurrence is gone. And so the emphasis there is on the presentation of the individual and the ability of the individual to rationalise their circumstances and rationalise the conditions to which they'll be exposed on return. And the significance of that in this instance, because as the court in Y flags, there has to be a platform from which to indicate that the person will be exposed, will present with a fear on return that could exacerbate the condition. There must be evidence-based, and we say that is the case here. We have expert evidence which identifies that the appellant lacks the capacity to rationalise her circumstances generally. And so one instance of significance is this. One of the observations made by the first-tier tribunal judge, for example, was that having concluded that there was no risk of harm in relation to state-related activity, the appellant would not consequently, the Dr. Heke's conclusions as to the potential bearing of that threat on the appellant's exposure to deterioration didn't bear. But the reality is that that's not a position that the judge could properly assume, because a necessary part of this evaluative exercise, which failed to be assessed, is that in the appellant's already reduced state, and in the predictable reduced state, further reduced state that she'll experience by the exercise of removal, and removal from the established care regime, will she be able to rationalise that the risks that she apprehended subjectively previously will not manifest prospectively?
But is she cognitive? I mean, was there evidence from Dr. Heke that she's in the second report, by which time her mental functioning had declined further? Is there any evidence in that report that the appellant was fearful of return on the grounds that she'd be persecuted on return?
Yes, Judge. I'll take you to it. Dr. Heke, in the second report, flags up initially the features of the appellant's presentation which caused her concern and indeed caused her to reappraise her initial diagnosis and to elevate her predictions, both as the quality of the condition, the severity of the condition, and the quality of the risk to the appellant of any removal from her existing care and support networks. And one of the factors that she fixed upon was that outlined at page 144 of the supplementary bundle, the second report. It's paragraph 3.2.23.
Sorry, page?
Page 144 of the supplementary bundle. So there you have an indication from the instruction that the expert received that the appellant's I asked the appellant if she could give any examples of when she felt she had made a mistake, and she referred to recently having cut her hair and confirmed that this was due to worrying that she'd be recognised by her past persecutors. And he goes on to then cite what she said. Yes, for example, I don't know if you know, I cut my hair and she said I shouldn't cut it. And goes on, yes, I was worried about being recognised. So this is the appellant's description of physical reaction to the fear, the subjective fear that she's describing. And that physical reaction establishes that fear is real for her, regardless of what finding the judge makes as to the objective reality of it. Now, significantly, the expert then goes on to consider that, and at paragraph 5.1.5 on page 147, she says this, under the heading of major depressive episode.
Sorry, can you just give me
Sorry.
a second to catch up, please?
So that was
5.1.5. So the expert says, I think probably it suffices to read the last 4 lines. The cutting of her hair, as she believed she...
Well, you need the previous sentence as well, don't you?
P in her witness statement described how her mother continues to experience panic attacks. Cutting of her hair as she believes she would be recognised and previous persecutors is not, in my opinion, anxiety-based, but is a factor of her being unable to rationalise these fears and recognise that she is not at current threat. And so what this describes is essentially another consideration which properly should have been factored into the consideration of the risk of removal, is that this is an individual, which perhaps would be obvious given the previous judgments of the tribunal as to her lack of capacity and the character of that, the way in which that lack of capacity presented, so that she's unable to rationalise away the existence of fear which has been termed to be objectively unfounded.
But the reasoning in YL that you took us to deals with the relevance of an objectively ill-founded fear to a risk of suicide on return. And as I understand it, Lord Justice said he was saying that a subjectively ill-founded fear can be relevant to the risk of suicide on return. This is a completely different case. No one's suggesting that the appellant is at risk of suicide on return.
But what is relevant here, Your Ladyship, is that one of the predictors which has been consistently flagged by Dr. Heke as potentially exacerbating and elevating the risk to the appellant on return are her apprehensions about what she would encounter there.
Your point is that by analogy, even if there's no risk of her being persecuted in Congo, if it's in her head that she will be, then that is likely to impact her behaviour, cutting her hair, panic attacks.
Precisely,
even though there's nothing in it.
Exactly right. And it will then, in turn, it will impact on her, if it impacts so as to cause a degeneration, which is what Dr. Heke predicts. And importantly, I do flag this, when one reads the passages from Dr. Heke which speak about risk related to actions by the state, she does not, in my submission, communicate a proposition which the first-tier tribunal judge infers, that she doesn't determine the implications of that on the basis there is a risk. What she does is she speaks about the appellant being convinced of there being a risk. That's the language that she uses. And there are further references to that in the reports. But
do you want to give us the paragraph numbers so that we can look at them later, please?
just have a moment. Yes, the relevant paragraph for that proposition is paragraph 5.5.1 of the first report, which is that's at page 120 of the supplementary bundle.
Okay.
The expert says Annie is convinced, following the threats and summons that she has received, that she will be targeted. And again, as your lordship has flagged.
First report?
Yes.
I thought you said second, but it's for the first.
You said first report, and
Okay.
it is the first report.
So it's 551 at page 120.
120, and it's about the sixth line down.
Just remind me, did the first-tier tribunal accept the evidence about the threats and the summonses?
No.
No. So the premise of that is that she'd received threats and summonses which she hasn't in fact received.
Correct.
Okay, well, that's helpful.
But that's our submission is that with a person such as the appellant, that has become meaningless because her condition and presentation is such that for her that is a reality, a subjective reality, and her remembering the observations made with regard to capacity, which I'm sure this court has seen before, because it's essentially the expert is channeling the statutory test, but the second report from Dr. Hecke, when she deals with the issue of capacity at page 148, she says at paragraph 5.5.1 on page 149, in my opinion, the appellant is not able to make all of these decisions, as she's unable to understand the nature of particular decisions, retain relevant information long enough to use it, weigh information given to make a decision, as I've already outlined. So this is a person who's not capable of balancing, retaining, processing, and formulating a response to, well, indeed any significant event in life, much less one of this gravity. So the assessment of what she would encounter on return and the implications of removal from this safe and secure network of support should have been performed in the context of an individual who lacked the capacity to process what was going to happen to her. Now that's just one example of a very specific example, and quite a critical example of how that return exercise will impact. But it is an example which one can extrapolate from, that in respect of other significant events, such as being confronted with an array of new carers, being placed back into an environment, her familiarity with which, contrary to what the judge says, is going to be impacted upon by her absence and by the fact that she has developed a degenerative condition over the period of that absence, which has caused her to lack the capacity to process information and make decisions. This is the individual that the judge is confronted with. This is the individual that the judge has to make an evaluation about. And this is an individual who the protective factors that reduce the implications for her of degeneration and the manifestation of risk have not been adequately evaluated. And we've established, we submit that the issue was one which, the question was one that naturally falls to be appraised upon an application of the Papage-Vilay threshold, the test, and
Well,
the
it's not
processes.
enough to say it naturally falls to be appraised. You've got to go further and say, as a matter of law, it must be.
And then I say, as a matter of law, it is an assessment that should have been performed. It's a natural part of the, as a matter of law, it is necessary to evaluate the consequences for the individual, on the individual facts, of the treatment, in this instance, the removal, on their existing health condition, and the consequences of the impact on the care arrangements for which we treatment and deprivation of the existing care arrangements of that exercise, and to a return to an environment which for this individual will be an unfamiliar one and a dangerous one in her perception. And so her capacity to resume and assume and accept care from other people will be compromised by the way that she reacts to that exercise.
So are you criticising the FTT at paragraph 232 on page 137 of the full bundle?
Yes, but I'm also criticising the FTT.
232.
Can you just let me catch up as well, please?
It's really the second part.
Yeah.
And indeed the last sentence.
The criticism is specific to that, but broader too, which is essentially that what is missing in this evaluation, it's missing completely in the Article 3 evaluation, incidentally. I think there's negligible engagement with the appellant's mental disability in the course of the Article 3 evaluation. The focus is on her mental health issues and on her physical health issues. Her mental disability doesn't appear to be critically evaluated there. And we say too that is as much as the judge has articulated the findings of the expert fairly thoroughly in the body of her determination, when it comes to evaluating the conclusions that she arrives at both in the Article 3 context and then in the Article 8 context, do not properly reflect the severity of the conditions with which the appellant presents, nor do they properly reflect the predictable consequences of the predicted consequences of the event which the appellant is being confronted with, which is removal, and the implications of that for her her health and her risk of exposure to serious and irreversible harm. And it all it boils down to that. Now, I handed up to you, Your Ladyship, that schedule earlier on, and I do just want to draw a few points to your attention, which really I don't need to go through them in detail, but I ask you to consider and weigh them up. The way that the appellant was presenting before Dr. Hecke, and consequently the expert evidence, condition of the expert evidence at the time that the appellant was assessed by the tribunal. On page 2.
The scope for the tribunal to assess was rather limited because she didn't give evidence, so it's an assessment based on written evidence.
It's an assessment based on
Well, she heard from the
consultation with Dr. Hecke, Your Ladyship, on 2 separate occasions.
Yeah.
So it was.
But the only point I was making was that the appellant herself didn't give evidence.
No.
I mean, that's an important point with regard to a latter stance that the tribunal takes, but I'm not sure that anyone would suggest that any sort of negative inference be drawn from it.
No. I was just making that's a point that's relevant to the FTT's ability to carry out an assessment.
Thank you. I think Rose, you, Mr. Jones, referred to the tribunal's assessment of your client, and my lady simply said, well, your client didn't give evidence. That's
Yes,
but where would you like to take us in this schedule?
I just commend it to you, really. I'm not proposing to take you through it, but what you'll identify when you read through that is just the level of impairment that the appellant is experiencing within the realms of this stable and secure environment that she's currently residing in. And I ask you to bear in mind, recognising the obligation, the legal obligation expressed in Papashvili to conduct an individualised assessment referable to the characteristics of this appellant: sex, age, disability, vulnerability.
Are you suggesting that the FTT didn't do an individualised assessment?
I am suggesting that
I've rarely seen such a long and detailed determination from the FTT.
I accept. I mean, I won't make any remarks about length not being necessarily determinative of quality, but I make the observation that, yes, I make the submission that when evaluating ultimately the issues with regard to health, there are deficiencies in the judge's disposal, principle within which is the...
Sorry, what do you mean by disposal? Do you mean reasoning?
Yes.
Disposal and reasoning are 2 different things, so you're criticising reasoning.
Yes. Apologies. And those deficiencies in reasoning relate principally in our submission to a failure to properly apprehend the quality of the appellant's impairment, and to then exclude from evaluation of the implications of return material matters including
properly apprehend quality of
the appellant's existing impairment, and to exclude then from the evaluation of the impact of return material factors that bear on the likely reduction of that already serious health condition. And I do flag...
You've set out in your skeleton somewhere what those points are.
It's the form of impact.
Well, what the submission is based on.
It's set out in the skeleton because we set out extensively Dr. Hecke's expert evidence, and we describe in the skeleton what Dr. Heke is predicting.
Yes, but sorry, I'm trying to get a handle on what is the criticism of the judge in what is very extensive reasoning. So you're talking about deficiencies in the reasoning. What deficiencies?
Well, we've identified the principal one, Your Lordship, which is relating to the failure within the Article 3 assessment, which the Upper Tribunal accepted existed, but didn't accept was an error of law because they concluded it hadn't been put, which was the failure to grapple with the implications of removal by reference to the loss of the existing care arrangements and how that would bear on the appellant's health and how it would trigger a deterioration on Dr. Heke's prediction on those, in particular, those two elements of the two reports that we looked at earlier in some detail.
Thank you.
And then adding to that, the failure to properly appraise the appellant's inability by reason of her lack of capacity as a consequence of those conditions to actually rationalise and process and manage the consequences of that return into a return into an environment where one looks at the symptoms with which the appellant presents, as I invited you to do, where she is already struggling to process her existing and settled environment. And that the combination of those factors, when put together, is amply capable of taking the appellant over the line, where what we're concerned with here is a neurodegenerative condition where deterioration cannot be resolved by the prescription of drugs or the extension of therapy. It is ultimate and final, and that the implication of triggering of enabling events which trigger a more rapid deterioration is profoundly important, because for a person such as the appellant, the window of lucidity that she will enjoy is measured likely in months and a few years. If you trigger a more rapid deterioration, that window gets smaller, and within that rapid deterioration, she is experiencing, because the rapid deterioration.
Can you give any evidence about what you've just called a window of lucidity?
That's my characterisation of what the.
No, I'm asking you, does Dr. Heke talk about this window of lucidity and how
No,
long
she
it's
doesn't use those words. That's my more flamboyant
No, all right.
interpretation of what she says. But Elisabeth, if I can take you to, we've looked at some of the references already where she's predicting she's identifying a predictable deterioration in the appellant's, both the
Yes, but
appellant's.
you haven't referred us to any passages where Dr. Heke puts a figure, like months or years, on this.
Well, I think one can do it quite straightforwardly by looking at the two reports and seeing that over the space of just 6 months between October 2022 and April 2023,
Right.
the appellant's facility with memory, concentration, the ability to communicate, self-care, all of that deteriorated markedly to the point where the expert was elevating to a significant extent her initial and with more certainty her initial diagnosis. So if one considers the rapidity of that decline in that safe and secure environment, one can extrapolate reasonably what the likely consequences of likely decline would be of a passage of time over a dramatic change of circumstances. And that is what I accept that both the legal argument and the expert evidence could have been communicated. The position I'm advancing could be communicated with much more clarity. But that doesn't mean that the information, the evidence is not there. It merely means that one has to engage more carefully in a more considered way with that evidence and draw appropriate conclusions from it. And it's necessary to do that given the gravity of the issues with which one is confronted and the gravity of the consequences for this individual. And it is not a significant struggle for a person to perform that exercise. It is what I'm describing is quite readily ascertainable from a straightforward review of those two expert reports and the changes that have already occurred and the predicted changes that will occur.
That's your submission.
That is my submission.
Yeah, all right.
Right. So I keep looking at the clock and thinking only 11 minutes have gone by since you got to your feet, Mr. Jones. But in fact, it's
Which is a relief, Your Lordship.
tad
It feels like a lot longer.
They've
if
been
I-
very enjoyable 11 minutes, but it's nearly 1:45. Now, how are you progressing with your submission in terms of
So-
time?
If I could just have a moment to kind of gather myself, because I've moved around a fair amount.
Entirely in your hands, and this is important. And the permission was given partly because it was compelling to do so because of the importance to your client. So,
Yes.
if you wanted to have a short adjournment now, so you can take stock,
Would that be all right?
and then address us
I would appreciate that. I think it could be more efficient.
that, and then, because we've covered a lot of ground and we've, as it were, taken you to different aspects. I remain keen on understanding what you say about the case of Lada, and in particular, it's plain there that the judgment of the tribunal talked about the new regime, and as I understand that, that's the president's guidance that was given, and the need to plead your case and be clear about your case, and work within the limits of it. So I'm keen to understand that more generally, and because I suspect this is the first case directly on that point that's got to this court, and it would be helpful to understand what you may say about that.
I
If
think
it's
I will be
convenient.
able to move on to that.
Should we
Can I just raise
Yes,
another-
yes, do.
But may I also raise another question, please? There's no reference, as far as I can tell, in the FTT's decision to Part 5A of the 2002 Act, which I find slightly puzzling. Is there some reason why it doesn't apply?
Excuse me, I turn my back just to.
It's cool.
I need help as to what that-
Regime for dealing with Article 8
So,
cases. in
I think-
tribunal.
Your Ladyship, I don't think that I'm not sure that the judge articulates by reference to specific sub-paragraphs of section 117B have
Well,
position.
I haven't seen a reference to Part 5A at all, but maybe I've just read it too quickly.
I think it is there.
Is it?
Well, shall we park that as well?
Well, let's
if I
park
just-
that. But I mean, I'm right in thinking that Part 5A does apply to the Article 8.
It does, Your Ladyship. I think you'll find it at page 141, paragraph 254 to 257, but it's not
Okay.
specifically referenced to the statute.
I mean, there are references to the immigration rules, but I haven't seen a reference to the statute.
I'm implying it's dealt with there because of the considerations that are flagged.
I think you're inferring rather than implying. Yeah,
I'm
okay.
inferring, yes.
All right. That's helpful. Thank you.
Good. So, well, shall we say quarter to two? Thank you.
Court rise of April